Ladies and gentlemen, brothers and sisters, friends, enemies, and comrades, I hope you're doing well wherever you are. It's afternoon in Kenya, around lunchtime in Europe, early morning in the western most at in America. If you're in Asia, it's probably at nighttime. Karibuni, karibuni, karibuni. This is Kenya Revolution. Karibuni, karibuni, karibuni. Hey, today, just in a few minutes, we shall be transmitting to you, showing you what's going on in the courts regarding Gachagua. Today, we are going to have a ruling, not necessarily on the impeachment itself, but whether the three-bench judge, Judge Murema, I forgot the two other judges. I just know Murema. They will be judging on, they will be ruling rather, whether they'll be stepping aside and not presiding over the case since they were, impaneled by the deputy CJ, the deputy Chief Justice Mwilu, which is in contravention to Article 165.4, which requires that the Chief Justice, Koome, is the one who should choose an even number of judges, not less than 3, to preside over this case. So I'm about to show you the live proceedings as it happens. It's supposed to start in a few minutes. But let's discuss a few things. What are we going to be looking at today? And what's the cause of this whole protracted process here? Why is it taking so long? Because there's a bunch of applications, there's a bunch of petitions that are put forth. And if this court won't take up this case, that means that it has to go back to Koome. Koome has to again choose another 3-bench judge or something like that. Then we have to go through. Then the matter will start. They'll start combing through the matter. Okay. But before I get started with all that, please go ahead and subscribe, share, like, comment, subscribe to the channel. Subscribe. Don't forget to subscribe. Subscribe if you haven't subscribed. If you're new to this channel, this is Kenya Revolutionary. We talk about Kenyan politics. Hi, Laban. I see you in the comment section. Karibu sana. Please go ahead and subscribe. Now, we're about to find out because the ruling is supposed to happen at 3:30, I believe. 3:30. We are just about 8 minutes before 3. So we'll see. But I just want to highlight. Let me show you something, some interesting tweets, but that people who have been in the judicial system were tweeting. None other than Grand Mullah himself. Okay, he had some interesting tweets regarding this matter, and I will be reading what he said and his prediction of what is most likely to happen. Okay, again, welcome, karibuni, ingieni. Do not forget, please subscribe. Take a minute, take a moment just to subscribe. Okay, it's free. It doesn't cost you anything. It's free to subscribe. Just go ahead and do that as we keep on bringing you this event regarding Gachagua. Subscribe and like the video. Like the video so that this channel can go out. The algorithm kicks the channel out there so people can get the message, and we get more people involved in these discussions as this event. So hold on. All right, let's get started. Oh. All right, so are you ready, ladies and gentlemen? Let's start with the first video, okay? While you like the video, I'm giving you a few minutes just to kahawa hapa mpaka tukunywe kahawa. Take a minute and subscribe to the channel, and take a minute to like the video. Let's get to the first video as we are about to get to the ruling and what's going to happen, okay? Just go ahead, subscribe, like, share. I'm giving you a few minutes to do that. Settle down. Then here we are. Let's listen in to the news a little bit. It's brief.
3-judge bench is this afternoon expected to deliver a ruling on whether they will disqualify themselves or proceed with a case challenging orders blocking the appointment of Kithure Kindiki as the deputy president. Justices Eric Ogola, Anthony Murima, and Fred Mugambi set the date after parties on Tuesday submitted extensively on the manner in which they were appointed to hear the case. Deputy President Rigathi Gachagua, through his team of advocates led by Senior Counsel Paul Mwite, argued that the only person who can impanel a bench is the Chief Justice. Let's now join our reporter, Kagonye, who's joining us live from the court. Kagonye, good afternoon. Talk to us about how we got to this point and what we should expect going forward.
Okay.
From the military, day re-judge bench is expected to over the President Gachagua and the three-judge bench Gambi. Now today, they are delivering a ruling that challenged the empanelment of the three judges, and the empanelment was done by Deputy Chief Justice Philomena Mwilu, and this is one of the issues that was very contentious yesterday. We were here yesterday from 11 a.m. up until 7 p.m. When they retreated and said that they will deliver a ruling today. I am joined by lawyer Danstan Omari, who will help us answer those questions. And for starters, Wakili, thank you very much for joining us here at KTN. For starters, today at 3:30 p.m., we are expecting a ruling.
Yes.
What are the likely scenarios from the ruling?
Well, the ruling is purely a question of law, whether the Deputy Chief Justice has jurisdiction to empanel the bench. Our position from Gachagua's side is that she doesn't have. The position of the speakers and the state is that she has. The outcome has far-reaching ramifications. If Gachagua and his team succeed, then the bench that is proceeding must down its tools. That is how this matter is. If the team of the state succeeds, then the next thing will be that Gachagua has lost, that the bench is completely empaneled lawfully. The way forward, that is, it is a cliffhanger. The second issue that will come on our side, the moment if we lose that petition, remember, the decision of the court is not final. There are three options. If Gachagua loses, we can ask for stay so that we appeal to the Court of Appeal. Over that question, we have a right to appeal. The state equally has a right to appeal to the Court of Appeal. And that simple question can still move up to the Supreme Court. These are preliminaries. The second issue, after the decision, we are saying the panel sat on a Saturday. That is already an application that is there to recuse the panel, the bench to recuse itself on two grounds. One, it sat on Saturday. Two, the lawyers were not present. Three, notice was not given. Fourth, Saturday is odd hours. That question is we are moving to ask the court to recuse itself. So still these are pending preliminary matters. And the journey looks that it will take long, as I say on KTN News. Out of the technicalities, the legal procedures, and precedents set in court, Gachagua is likely to be in office up to 2027, pending the outcome of the Supreme Court.
So thank you very much for having us, for talking to us and for enlightening us on what to expect from the bench.
And remember, our petition, some of the petitions that we filed have not been listened to. We wrote a complete letter to the CJ in the morning saying we need those petitions that were selectively left out to be brought before the court so that this court deals with them. We expect feedback when we appear at 3:30, that position. Four, there are other issues preliminary to this matter. Remember, Senior Counsel, Dr. Hamino raised a question. Where are we running to? Why are we turning this thing a Simon Makonde issue? Why are we doing Safari Rally the way it was done in Safari Rally in National Assembly, Safari Rally in the Senate, Safari rally in court. What is the urge about this matter? But my take as a citizen, I urge the country to be calm. I urge every citizen of this country to be patriotic and allow the constitution to take place. There were those who are advising that the courts have no jurisdiction to interfere with the Senate, to interfere with the National Assembly. Now they have learned the law properly, that there is no tribunal in this country that can sit and exclude the jurisdiction of the High Court, the jurisdiction of the Court of Appeal, and the jurisdiction of the Supreme Court, and including the East African Court of Justice in Arusha.
Thank you very much, Mr. Omari. Take time. So, actually, that is lawyer Danson Omari, who's part of DP Gachagua's legal team. And how we got to where we are, just to answer your question, is when this process began, a number of cases, that is the impeachment process at the National Assembly, and then before it went to the Senate, a number of cases were filed seeking to stop the impeachment process. These cases are more than 20, and the orders that were sought is to stop that whole process. But the deputy president's side did not secure the orders that they were looking for, and the same bench sat last week, and one of the cases that had been brought before them because Justice Bahati Mwambuye, after receiving the application for the orders seeking to stop the impeachment process, forwarded the file to the Chief Justice for impanelment. And the three judges that we've mentioned, that is Eric Ogola, Frida Mugambi, and Anthony Chao Mrima, sat and did not grant Gachagua the orders that he sought. And they said tomorrow is the mentioned date for the cases. Now, after Gachagua was impeached on Friday, they filed other cases, some in Kerugoya, at the Kerugoya High Court, some here at Milimani. Among the cases at the Kerugoya that were brought here have been the case number now is E013 and then E014, E015, which are already here, and the three cases are now before the three-judge bench, and they have been converted to become petition numbers E565 of 2024. Now, among the orders that came from Kerugoya, the Kerugoya High Court was one that was barring Interior CS Professor Kithure Kindiki from being sworn in as the deputy president. And after the orders came, the AG and then the lawyers representing the speakers of both the National Assembly and Senate, and then the lawyers representing the Senate and the National Assembly, as well as President William Ruto and Kithure Kindiki, that is the Interior CS, they went again before the High Court and they sought to have some of those orders that had barred the swearing in of Kithure Kindiki to be varied, and that's why the bench sat on a Saturday. Now, that was the bench. Why the bench sat on a Saturday, and among the many things that was an issue of contention was the empanelment of this bench, which was done by the DCJ, that is Philomena Mwilu. So today, that is the ruling that we are expecting. Whether the judges will find it fit to hear these cases all, they will recuse themselves. Actually.
All right, thank you so much, Fred Kagonye, for that.
Okay. So you can see very quickly, we want to see what we are going to be looking at as far as, if I may, let me show you real quick. So today we are going to, there's a couple of things. The number one, what needs to be established, the first thing that needs to be established by the courts is if they have this jurisdiction in this matter. When I say jurisdiction, I just mean does this three-bench panel bench, Justice Murima, what her name, Ogola, and the other lady, I forgot her name, do they have, can they preside over this case? Because like I said, they were handpicked by, they were impaneled by the deputy chief justice. And I say it again, the law requires that it's the chief justice, not the deputy, but the chief justice. Under Article 165.4, it says that the chief justice is supposed to pick the three panel judge, or not less than three, an even number, not less than three, to oversee this matter. But that seems not to be the case. So the court will first establish if they will be presiding over this case. If not, again, the matter will go back to Kome. Kome will have to do the other thing again. But it can go either way. They might decide, hey, listen, we are going to preside over this case. And that way, you had, like the gentleman say, Danson Omari said, they can request a stay order or whatever. That way, they can appeal in the courts of the appeal and move it up the rank in the courts up to the Supreme Court. You never know. So it will be very interesting to see what the court decide, if they're going to go on with this case or not. Here's what's interesting, what Abdel Nasser wrote on his tweet. Please, ladies and gentlemen, take a moment before I go on. Please take a moment to like this video and subscribe to the channel as we go on. I see you guys, Brian Nyabuku. I see you in the comment section. John Orena. I see you, Laban Misiani, as usual. I also see you there. Thank you so much for joining us. Please like the video and subscribe, share, like, and comment. Okay, here's what Abdel Nasser said in his tweet about this whole case as we wait for the ruling. Let's read some of the tweets. Abdel Nasser, as you know, he was barred from the Supreme Court, and he always have a gripe with the judicial system, highlighting the kind of corruption that happens there. But that's another case for another day. Let's just focus on what he wrote in his tweets. Can you guys see the screen real quick? Okay, so here is what Abdel Nasser Abdullahi, the Grand Mullah, as you call him. I don't usually take him. Well, he has a point, but sometimes he's always off. Goes off the rail. But it's normal. Here's what Abdel Nasser said. Number one. So today the High Court will rule on whether the DCJ Mwilu, DCJ is the Deputy Chief Justice, Mwilu has powers to impanel judges to hear constitutional petitions. Gachagua will not win this. According to Abdel Nasser, he says Gachagua will not win this. Number two, if you guys can see the screen. Number two, then the court will hear the disqualification application where Gachagua will not win. Again, according to Abdel Nasser, he says Gachagua will not win on that too. Number three, stay application pending appeal will be argued. Gachagua will not win. As again, I mentioned there'll be stay application to halt the case so that they can appeal and go to a higher court. Okay. Number four, application on whether state offices in the Senate and the National Assembly, including departmental heads, can represent parties in court will be argued. Gachagua will win this. Now, this one in number four, if you're watching the screen, ladies and gentlemen, brothers and sisters, this number four deals with the fact that the state offices, the Senate was being represented by Ojienda, I believe. Ojienda was representing the Senate, and the National Assembly was being represented by I think it was Githu Muigai, I think. So that's where the argument is: can state offices be represented by a lawyer? And that's where number four, Abdel Nasser is talking about here. Application on whether state offices in the Senate and the National Assembly, including departmental heads, can represent parties in court will be argued. And in his view, he thinks Gachagua will win on this. I found it very odd for lawyers to represent the National Assembly and another lawyer representing the Senate. That was really odd for me, but hey, I don't know how that works. We're about to find out in the courts. Number five, he says, then the main application will be heard. The main application, I think it's to do with the actual impeachment, but they will not rule over that. They'll just hear the cases, okay? It's going to be a long process, okay? They might go to midnight. Then number six, ruling next week or the end of the month, inshallah, God willing. So according to Abdel Nasser, he thinks maybe the ruling will happen sometime next week or maybe, next month, because this thing is going to be a protracted process. Just like Danstan Omari said yesterday, this thing might take 3 years. I hope, God forbid, I hope it doesn't go for 3 years, because if it goes 3 years, that basically means we won't have a deputy president up to 2027. That's a little bit a stretch. I don't think it will go that far, because there'll be a lot of call for this issue to be resolved quickly, okay? Not necessarily quickly, but in a reasonable time frame where everybody is given time to be heard and all the cases of petitions are heard and all that stuff, and the ruling will be made. James would tell us that I'm not jumping on that regarding Gachagua sympathy train. Miss me with that BS, injustice notwithstanding. Right. Yes, I see what you're saying. Majority of the people don't sympathize with Gachagua, but they just don't like the fact that he's not being afforded the right to represent himself and the manner in which the National Assembly and the Senate were rushing to take him out, and they're rushing to bring Kindiki. It just showed that, it just brings attention, shows Ruto in bad light, because everyone now sees that Ruto is kind of the ventriloquist in this whole thing, moving things around and treating this National Assembly and the Senate, the legislative body, as his own personal, puppet. Okay, so that is what Abdel Nasser said about the issue. Now, there's also another tweet that Abdel Nasser had regarding this issue, and I will read it really quickly because I want to go live and show you what's happening at the courts. There you see, he also mentioned in the second, if you can see the tweets, ladies and gentlemen, I hope you can see the screen. Can you guys see it? All right, let me just move this so you can see what Abdel Nasser was saying about this. Number one, the conservatory order will be discharged by the 3-judge bench latest by next week, if not by Friday. So if the conservatory order is discharged, if it's removed, that means Kindiki will probably be declared, they will go ahead and try to, apewe kipao. Kindiki will be atapewa kipao and become, the deputy president. He will be sworn in, okay? If they remove the conservative order. So number one, Abdel Nasser Grand Mullah said the conservative order will be discharged. This is his on his view, okay? This is what he thinks will happen. The conservative order will be discharged by the 3-judge bench, this one currently one, latest by next week, if not by Friday. 2, Professor Kithure Kindiki will be sworn in as deputy president. 3, both the High Court and the Court of Appeal will quash the impeachment of Honorable Rigathi Gachagua on the ground that he was denied the right to be heard during the Senate trial as he was sick, okay? Both courts will order his immediate reinstatement, okay? 4, the Supreme Court deploying juris pesa. Juris pesa basically means, the jury being paid, the judges being paid, okay? Money will exchange hands, corruption. The Supreme Court deploying juris pesa will hold that fine. Gachagua was denied the right to hearing, but he can't be reinstated as Professor Kindiki is in office, okay? Number 5, somewhere in between, don't rule an out-of-court settlement whereby Gachagua's impeachment is set aside and he agrees to go back to Madeira to fight another day. So Grand Mullah is saying that the conservative order will be removed, will be discharged, and once it's removed, Kindiki ataapishwa kuwa naibu rais. Then after he becomes that, the court will still go on and rule that this impeachment process was, Rigathi Gachagua was denied his right and all this stuff. Then he will be reinstated, but they'll rule that Kindiki ameshawekwa, so we have to move on. I don't agree with Grand Mullah on this because I think there's so many reasons. Lawfully, I don't think Kindiki can be the deputy president. There's so many reasons why. Number one, he wasn't a UDA party member 6 months ago. Number 2, he was not vetted. Remember, the IEBC has the powers to vet Kindiki, which is not the case here. I know a lot of people think that the parliament or the National Assembly does the vetting. No, the National Assembly only votes to approve or disapprove of the president's nominee, okay? But they don't do the vetting. The vetting happens with the IEBC. That letter that Ruto got from the IEBC was the letter from the CEO. And remember, the IEBC cannot discharge its function if they do not have a chairperson and they do not have a commissioner. So Ruto cannot claim that Kindiki was vetted. He was not vetted, okay? So that's the case. Anyway, I'll read this Ninio, then I'll take you. Let me see if the court has started meeting. What I want to hear is Friday we go to parliament. Hii ya Gachagua tuachie wenyewe. Hawa watu wako busy increasing their term office. Yeah. Jamaa wanatuchezea. So we shall try to go to the live Ninio and see what's going on in the courts. It's popping already. So let's go to the courts and see what's going on up there. Washaanza kuninio kutana. I see Nelson Harvey and the gang already seated somewhere, ready to have this thing linear. So let's go and listen in to the courts as they will make their. Ladies and gentlemen, make sure you subscribe to the channel. All of you watching, please go ahead and subscribe if you haven't subscribed, and share, like, comment, and do all the good stuff. Okay.
Matters. Our matters are only 3, and those are the matters that we are going to hear. So today in the afternoon, we've seen that the Chief Justice has responded to that letter, saying that all those matters are going to be heard this afternoon at 3:30.
Well, you put it right. And even as we wait for this particular landmark ruling regarding whether the Deputy Chief Justice Philomena Mwilu was in accordance to the law and to the laid judicial statutes in constituting a 3-judge bench in the absence of Chief Justice, whether it was accordance to the law or not. We have other interested parties coming in this particular case. Yesterday, of course, Zuya, we saw a very congested courthouse, the Constitutional Division court number 14 of the High Court, in attendance, none other than the Chief Justice himself. But talking about people who are really into seeking determination of today's ruling, one of them, like you mentioned, Dasson Omari, he is here with us. And he could just come on the side here. Yes, Dasson Omari, we saw yesterday, I beg your pardon, I say the Chief Justice, no, the AG was in attendance, Kasodwar, and also a former AG, Gidu Muigai, who's also the AG's counsel in this particular case, including the Solicitor General. But we saw you filing a letter today directed to the Chief Justice, and she has responded. Are you now satisfied by the answers that the Chief Justice, has indicated in that particular response?
Yeah, yesterday we were told that we are not part of the proceedings, and we requested.
All right, we have Steve Ogola with us in studio. Wakili, is this the first time a Deputy Chief Justice has appointed a bench?
It's not the first time, and I think the court had yesterday instances when the Deputy Chief Justice has exercised this administrative function. But let me not preempt the ruling. The purpose of today's ruling is to determine whether the appointment of a bench is a judicial function or an administrative function. If that appointment is considered as an administrative function, then the short answer is yes. The DCJ, Deputy Chief Justice, may in fact, or need by need, appoint such a bench. And this is not the last, neither is it. This is not the first, neither is it the last.
So what is the legal framework? What provisions of law are they going to be looking at?
Now, if this is a judicial function, then the Deputy Chief Justice may not appoint that bench. I think from the arguments that we had yesterday, the rival counsels that the Deputy President's counsel said, the decision or the function of appointing or empaneling a bench is a judicial function reserved exclusively for the Chief Justice. We will know whether there was merit in that argument, but I can tell you the appointment of or empanelment of a bench is a routine day-to-day administrative function.
So are there like judiciary standing orders similar to what is in Parliament? Are they looking at the Judiciary GSC Act? What are they looking at?
Well, you have the High Court Organization and Administration Act that generally provide a framework on management of courts, the High Court. And the Chief Justice core role within the Constitution includes organizing the composition of benches such as this. And it's just administrative, like deciding. Actually, it's not just the Deputy Chief Justice or the CJ that do this. Even the principal judge,
can determine who sits where in the normal course of judicial work. Even the executive officer can determine. An executive officer is an officer who manages cases when they are filed and does the allocation. So an executive officer can decide which magistrate sits on which file. Because ideally, when you file a case in whatever level, small claims court, chief magistrate's court, you don't determine who handles what. That decision is made administratively based on the existing workload, and it has never raised an issue. But you never know, maybe there's an occasion now to reinterpret the law. But I think the law as it stands, and if the court interprets it differently, we'll all get to know. But as it is now, Olive, the appointment of benches is reserved for the head of the judiciary, who is the Chief Justice. But when the Chief Justice is incapacitated or is unable to do so, he doesn't need an executive order delegating that function.
So is this a function that is routinely delegated?
It's routinely delegated and can be done by the Deputy Chief Justice without raising an illegal issue.
But in this case, why is this a critical ruling?
Well, it's only critical in the sense that it implicates the timelines for resolution of the two pending applications by the National Assembly and the Attorney General, and the application by Mr. Gachagua. Otherwise, if those applications were not pending, there would be nothing that would be critical, and I dare say nobody would have raised the question of composition or the appointment of the bench. Every day, myself was in court in the morning, where a file was referred to the CJ for impanelment. Usually when that bench comes back to us, ordinarily lawyers don't ask who constituted the bench, because we understand it to be an administrative function. What lawyers are prone to question, and we do question that every day, is the neutrality and impartiality of that bench, which can implicate its capacity to do justice to the case. If I fear that this particular bench or a judge will not do justice to the case, and to do justice to the case means that the judge looks at that case with the necessary impartiality and neutrality. If I don't see that, then I can raise a question of recusal.
So is that what is in essence, is in question?
I think though that question has been reserved, we will get direction. Whether these judges should recuse themselves, because you had that argument yesterday. Mr. Gachagua's lawyers made an express application that they would be happy to ask this three-judge bench to recuse themselves, because they didn't believe that this bench was appointed to do justice to the case. The allegation is the bench was appointed irregularly, outside working hours, and by someone who was ordinarily not authorized to make that appointment, and therefore they feared that the bench would not do justice to the case. So once the ruling has been made, and this bench determines that it can sit and that the appointment was regular and lawful, then they will raise the question of impartiality if they wish to. And I believe the court should be able to deal with it as a preliminary issue, and then be able to progress the next level. But I think the most pressing problem of constitutional relevance is the place of procedures and technicalities in impacting the administration of justice, expeditious administration of justice. You had the Attorney General in her opening remarks pleading with the court not to lose sight of Article 159, sub-Article 1 of the Constitution, that says the expeditious administration of justice or resolution of disputes must be a matter that must be given priority over technicalities. Because technicalities is the reason why we are sitting today to hear the ruling. One party raised a preliminary issue on a technicality. If you ask yourself, okay, arguably, assuming the Deputy Chief Justice does not have the power to appoint a bench, how does that affect prejudice as a party before that bench? How?
So that will be the question.
You see, now, no, that should be the question ordinarily.
Okay.
That should be the question ordinarily. But that question was not posed because lawyers wanted to ride on technicalities. Orders that they have, the deputy president enjoys ex parte orders that now stops the deputy president designate from being sworn in and assuming office. Professor Kithure Kindiki now cannot be sworn in because of the orders that were issued by the High Court in Kerugoya that stayed his swearing in, and the orders that were issued by Justice Chacha at the High Court in Milimani. The totality of those orders is that they have punctured the process of replacement. And Mr. Gachagua is very happy with those orders. So what the lawyers are doing, which I wouldn't at the hearing of the petition. But where we are now, if I attempt to sequence some of these petitions, the Olive, number one, we will get the ruling. The ruling will then determine the preliminary issue of impanelment of the bench. Number two, we will then get direction on Adrian Kamodo's application, which seeks to enjoin UDA to the proceedings. Since that application has not been responded to progress and to save time, it would make sense for both parties to then by consensus agree to admit UDA. Because if one party declines to admit UDA, and I can tell you, it would make strategic sense, because I've told you about technicalities, the place of technicalities in impeding expeditious disposal of cases before the court. If the DP side agrees or supports the enjoyment, the joinder of UDA, then we can make progress quickly. But is it in their interest to do so? If they oppose, then they'll ask the court, we were informed of an application to add another party who is not a primary party. We have not been served, or we have just been served. Give us time to put in our responses. And then we'll go to another round of filing responses, oral highlights, and then meanwhile, you're extending Gachagua's stay in office. Now, if we get past that level, then there is the other 3 applications that are pending. This bench, remember, was empaneled specifically to listen to 2 applications that were filed by the Honorable Attorney General and the National Assembly. The Honorable Attorney General filed an application imploring the court to set aside or discharge the stay orders that Honorable Gachagua now enjoys. The National Assembly filed a similar application, and all these applications are now before this bench. Ideally, this bench should have started by hearing those applications, not the preliminary issue of how it was composed. Mm-hmm. So that is the 3rd layer, the applications. The 4th layer is Honorable Gachagua himself has an application that has not been heard inter partes. Mm-hmm. Remember, when the High Court in Nairobi gave him ex parte orders stopping implementation of the Senate resolution, Justice Chacha Mwita said that application be heard inter partes on 24th, that is tomorrow. That application is now before this 3-judge bench. Mm-hmm. So then we need to take direction to dispose of that application as well. So in terms of neatness, since the applications by the Honorable Attorney General seeks to set aside Gachagua's orders, and Gachagua's orders application is also coming for inter partes hearing, it would make practical sense to hear the Attorney General's, the National Assembly, and the Honorable Gachagua's applications together, the 3 applications. Then we would hope that no further applications come. Now, if further applications come, and they may come because the people who are in other petitions that are not part of this petition have already expressed their grievance. And they have said, we also need to be heard on the urgency of our application. So what I suspect is this. The court might say, let us dispense of the 3 applications before us first. Honorable Gachagua's application for extension of those orders until his case is heard and determined with finality. The Honorable Attorney General's application to discharge Gachagua's applications, and then the National Assembly's application, which also seeks to discharge those orders. If the High Court gave the bench gave directions to dispose of these 3 applications first, there would be neatness and order in the court, and then it would also work to reduce the public anxiety. Otherwise, there's a risk that as soon as the court gives directions, somebody will raise an objection and say, we also want our applications that are not part of these applications to be brought before you. So it all boils on case management. It boils on court management of this bench or the proceedings before this bench. That is what I see. Mm-hmm. Mm.
So given these applications already before this bench, can another petitioner move to court, a separate court, and make similar applications?
That's why, yes. So I think because of the short answer is yes. there is no limit or bar on how many applications may be filed. Remember in the BBI case, people kept filing petitions, and eventually the court had to consolidate all of them. I think what other third parties who are not in court may want to consider is, before the court gives final directions on disposal of the petitions that are presently filed, they need to move with speed and file whichever petition that they think they need to file now. Because whereas the High Court cannot stop a litigant from filing a petition at whatever time, once they give the directions on hearing of the substantive petitions, they will not reopen that case management window. And then what will happen is what happened in, I think, Helef's petition, together with Justice Sam Mohochi's petition. In 2017, I think Helef filed a petition late, questioning, I think either they were questioning the constitutionality of they wanted to stop the fresh elections in 2017. That petition to date has never been determined, because fresh elections happened before it could be determined. Then there were presidential election petitions, by Africa challenging the re-election of Uhuru Kenyatta in that fresh election in 2017. Mohochi, now judge, together with Helefele, went before the Supreme Court and told the Supreme Court, listen, we also have a petition that we filed challenging the constitutionality of this fresh election, because they said IBC wasn't ready. The Supreme Court said, we hear you, but we're going to deal with the questions before us first. Was this election compliant with the Constitution, yes or no? When we are done, we can come back to hear any other matter. And to date, Olive, the Supreme Court has not prioritized or listed that petition that questioned the constitutionality of the 2017 election for grounds that they raised that the 60-day period, IBC had not made the necessary changes. So the point is, because of the multiplicity of petitions and the urgency of this particular petition, the High Court will draw a line quietly, because the Chief Justice can't call a press conference and say, dear Kenyans, we're very busy, don't file petitions on this matter. They can't do. But quietly, administratively, they will prioritize, they will do a cutoff date. And I'm sure the CJ has already made that decision, perhaps. Today is 23rd. If by 30th of October, for instance, no one has filed further petitions, anybody who files petitions after 30th, thank you, but no thank you. We're not going to deal with it.
Okay. So
they could say that so that they manage the time.
Okay. This is a highly politically charged matter, right? Just look at the advocates we see in that court. We have the Attorney General who was in attendance yesterday. We see their former Attorney General, Githum Wegai, already in court. Senior Counsel, Paul Mwite. John Haminwa, who had an exchange with Githum Wegai yesterday. So this is the creme de la creme, so to speak. How will this political environment influence, if at all, how the case management is undertaken?
And that's why my preliminary feeling, and I already have, I try to hazard this in advance, looking at the seniority of the bar before this three-judge bench. Remember, some of these senior lawyers were pupil masters, employers of these judges. The likes of Senior Counsel Paul Mwite, this John Haminwa, these are people who have practiced law for more than 50 years. Most of them have practiced law for more than 38 years. Chances are Justice Eric Ogola, Justice Frida Mugambi, Justice, the other judge, sorry for escaping, his name is escaping me. The chances are that they all, Justice Anthony Mrima. Chances are that Justice Anthony Mrima, Justice Eric Ogola, and Justice Frida Mugambi have all been mentored or trained by this senior, but so they are likely to be more accommodating. And that is where the risk lies. You heard yesterday, people made very liberal submissions that fell outside the issue for determination. And the judges tried as much as possible to accommodate them. Now, if that continues, then the judges will lose control of the case because there are different interests at play. That the court right now is a theater for political competition. There are people who say, how can we use the legal process to ensure that Honorable Gachagua continues as deputy president because he enjoys those orders? There are people who say, how can we use the justice system to ensure that Honorable Kithure Kindiki, the deputy president designate, is sworn in as soon as possible? Now, the politics will then find its way in the court. So what the courts are supposed to do is this. The court is supposed to read the mood, not in the room, but the mood in the country. Now, the mood in the country is this. There is a lot of tension and anxiety because you have a deputy president that has been impeached. And you have his replacement waiting at the door. Mm-hmm. He cannot get in, be sworn in and start serving because the judiciary said don't. There's a case before us challenging your nomination. So wait first until we deal with this case. This other gentleman, Honorable Gachagua, can't assume office until that case itself is heard and determined. So Gachagua is the deputy president by virtue of court orders. Professor Kithure Kindiki is the deputy president designate by virtue of the fact that the Senate already impeached Gachagua. So if the court wanted to elevate public interest above partisan, personal interest of the Honorable Kindiki and the Honorable Gachagua, then the court, this is what the court would do. The court might, and I expect this to happen, that the court must now issue final direction today on how these applications should be heard and determined so that the country knows, Olive, the orders that Honorable Gachagua enjoys, are they going to be extended pending the hearing and determination of the petition, yes or no? If they're going to be extended, then I can tell you the Attorney General will move the Court of Appeal. If they're going to be vacated, then it will pave way for CS Interior, Honorable Kithure Kindiki, to be sworn in immediately. And if those orders are vacated, even if Gachagua moves the Court of Appeal is unlikely to interfere because of that political stability and continuity in the country and in government. You have heard the concerns raised by, let me call him outgoing Deputy President, Honorable Gachagua. He has said, while in Kisumu and in Nyeri, serious attempts to poison him were made by security operatives. You've heard him contradict the president, says the president, my only fault is saying, Mr. President, don't press on with Adani. Look at the affordable housing. People are not happy with it. Look at SHIF. People are not happy with it. So Gachagua has publicly contradicted post-impeachment the position that is taken and advanced by government. It is untenable politically that he can go back to office, be co-opted into government and start working, even assuming that that's what the orders would say. Mm-hmm. It's untenable. So I think if the courts were to take into consideration the various factors, it would work in favor of discharging those orders. And I'm not in any way trying to undermine Gachagua's case, but I can tell you, if you look at the bigger public interest, the political wing of government that is mandated to hold the highest office holders to account. Because remember, the purpose of impeachment is to rein in on political impunity among or against state officers that may not ordinarily be taken to courts. It's unlikely that in our lifetime as a country, we will see the deputy president arraigned in court to be charged with ethnic incitement. Because that's a very huge step. Because who will be the arresting officer? The arresting officer will be someone without political capital. Incitement is a misdemeanor that will be charged before a magistrate. To arraign the deputy president before a magistrate or a high court judge raises serious concerns of the court's ability to listen and determine that case. And these are not concerns just in Kenya. These are concerns that framers of the Constitution worldwide grappled with, and they said, to hold the highest office holders to account, let us reserve that role to people with political capital, the people with a real constituency, the National Assembly and the Senate. So when the National Assembly votes overwhelmingly to approve the impeachment, Gachagua's impeachment, and the Senate votes to confirm 5 out of 11 counts of those grounds, Olive, forget about the law. In terms of practical sense thinking, Honorable Gachagua will not resume office.
Mm-hmm.
It would need a lot of re-engineering, political re-engineering for him. It's easier to accommodate a new person than to re-engineer the politics, because this is what must happen for the courts, for Mr. Gachagua, regardless of what the courts say. For him to assume office, it means the religious leaders must reach out to the president. The president must then apologize. There are things that are politically not tenable.
Mm-hmm.
Gachagua must also apologize for accusing the president of orchestrating the impeachment and so on and so forth. I think the court appears to have started.
All right. So thank you for that. Wakili Steve Ogola. We will now cross over to the Milimani Law Courts and hear what the 3-judge bench of Justice Eric Ogola, Anthony Mrima, and Frida Mugambi have decided on whether the DCJ enjoys the powers to empanel a bench or enjoy the powers to empanel this particular bench. Let's listen in.
Good afternoon, everyone. His Lordship, Justice Eric Ogola, His Lordship, Justice Anthony Mrima, Her Ladyship, Justice Dr. Frida Mugambi, on ruling petition E565 of 2024 regarding Gachagua versus State Law Office.
May it please you, my Lord. My name is Shadrach Moset, Solicitor General. Appearing together with Professor Gitu Muigai, Senior Counsel, that's for the Attorney General, Emmanuel Peter, Deputy Chief State Counsel, Charles Mutinda, Deputy Chief State Counsel. Then for the National Assembly, we have Elk Gumbo, appearing for the National Assembly, and Paul Nyamodi, and the Honorable George Gitonga Murugara. My lords and my lady, for the Speaker of the National Assembly, we have Benson Milimo and Josephat Kunyoni appearing for the Speaker of the National Assembly. My lords and my lady, for the Senate, we have Professor Tom Ochenda and Moni Mukele Edwin. For the Speaker of the Senate, my lords and my lady, we have Mercy Tanchi and Peter Wanyama appearing for the Senate, for the Speaker of the Senate. And for interested parties, my lord, we have Moses Kipkoge, we have Dr. Mutomi Tionkoru, we have Kenny Meli, and we have Boniface Mwelelu and Eric Murioki appearing for Professor Kitule Kindiki. Sorry, my lord, for the Senate, we have Honorable Hirali Sigei for the Senate.
In addition to Professor Tom Ochenda.
Yes, that is in addition, my lord, to Professor Tom Ochenda.
Hilary who?
Sigei. Honorable Hirali Sigei, Senator.
My lord, my lady, I'm present.
My lord, for the sixth respondent, much obliged, my lord. I leave it at that.
Thank you. My lord, for the sixth respondent, Dr. Kamodo, we continue to appear at a protest.
Kimoto Teresia Wanjiru, Judge Kimoto and Company Advocate for the second petitioner.
For second
Petitioner.
Yes.
And my lord and my lady, my name is Kip Mungai. I appear in this matter. And, my colleagues are Mr. Muge for the Sandegwa in petition number Kirinyaga, Kirwell, I believe it's Kirwell, 5015 for the petition.
Mr. Kibe, we consolidated and we came up with a new lineup of the parties. So it may not be very appropriate to keep on referring to.
I did take the notes, but I mean some of them. The person who took the notes is not here.
That's okay.
Yes.
We'll supply.
And I've not seen any order to indicate now that.
Okay.
So that I can.
We will supply after the proceedings.
My lords, your leadership, Paul Mwite, I appear with Mr. Soanya, George Sekimpa, and Tom Macharia for the Deputy President of the Republic of Kenya in the consolidated petition and in any other petition where he is a party. Thank you.
My name is Khamino. I appear for Kituo Syria. As interested party in E565 of 2024 with my land friend, Mr. John Maridi. I haven't seen him at the John Maridi, advocate. That I should Kituo Syria. And then I also appear for myself. You understand? That's
Good afternoon, my lady and my lords. For the third petitioner, my name is Moody. May it please you, my lady and my lords. My name is Nelson Harvey. I appear for the interested party, the Law Society of Kenya, together with my two colleagues, Jose Amanwa and
Where are
Kevin
they?
Michuke. Who are present here.
Mr. Jose and who?
Jose Amanwa and Kevin Michuke.
Where's Kevin?
I'm present. The man behind the camera.
Maybe perhaps for guidance on which matters we are taking quorum on, because this afternoon, and I believe my right friend Mr. Kibe will address it, we were served with a notice from the office of the Deputy Registrar indicating that there were several matters that were to be mentioned before you this morning, this afternoon, and last evening when you were breaking, we were to come for a ruling. Perhaps you need to have clarity that we may not have a mixture of things.
We are dealing with the ruling matter in which the ruling is supposed to be delivered now. After that, we'll give directions.
Then if the case there for the means there are some advocates who have gotten on record for quorum who did not participate or they are not parties in this particular proceedings. Like who?
Like Nelson Harvey.
But Lord, lady, we have asked the Lord to spend some little time on this meeting with his wife. That doesn't deplete the energies. There is no harm in I appearing on the record.
Is there any other concern before we read the ruling? Our ruling is ready on the consolidated petitions, with the lead file being petition number E565. We have set out the structure of the ruling, but we'll begin from our analysis of the issues that we think are relevant for now. This is the ruling. Having carefully considered the pleadings, submissions, and evidence on record, we consider the following issues arising for determination. One, what are the prevailing constitutional and statutory interpretation methods? Two, whether the Honorable the DCJ can assign judges pursuant to Article 165, Sub-Article 4 of the Constitution 3, other related matters. On the first issue, the Constitution is a document sui generis. It is the grundnorm which legally commands superiority and dominance over any other laws, and its interpretation, as of necessity, must be in a manner that all other laws bow to. The court in S versus Atchison, 1991, captured the centrality of the Constitution as follows. The Constitution of a nation is not simply a statute which mechanically defines the structure of government and the relationship between the government and the governed. It is a mirror reflecting the national soul, the identification of ideals and aspirations of a nation, the articulation of the values bonding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. In the matter before the court, the High Court has once again been called upon to address the issue as to whether the Honorable the Deputy Chief Justice of the Republic of Kenya, whom we refer to herein as the DCJ, can exercise the power of assigning and impaneling expanded benches of the High Court. As such, the interlink between Articles 161 sub-Article 2 and Article 163 sub-Article 1 and Article 164 65 sub-Article 4 of the Constitution, as well as Section 5 of the Judicial Service Act, come into play. On that score, it is paramount to briefly look at how the Constitution and the statutes ought to be interpreted. As a starting point, the Constitution itself provides for its own theory of interpretation. That is in Article 20, sub-Article 4, and Article 259, sub-Article 1. Article 20, sub-Article 4, requires courts, while interpreting the Bill of Rights, to promote the values that underlie an open and democratic society based on human dignity, equality, equity, and freedom, and the spirit, purport, and the objects of the Bill of Rights. Article 259, sub-Article 1, commands courts to interpret the Constitution in a manner that promotes its purposes, values, principles, advances, and rule of law, human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. In hailing the Constitution of Kenya as a highly transformative one, courts have over time developed various methods or canons of interpretation. In the case of David D. and others versus Attorney General, the learned High Court judges dealt with 4 constitutional interpretive principles, being that the Constitution must be interpreted holistically, that the Constitution does not favor formalistic approaches to its interpretation, and it must not be interpreted as one would a mere statute. The Constitution has provided its own theory of interpretation to protect and preserve its values, objects, and purposes, and that in interpreting the Constitution, non-legal considerations are important to give its true meaning and values. The Supreme Court, in the matter of the Kenya National Commission on Human Rights, Supreme Court advisory opinion reference, which I've given at paragraph 26, answered the question as to what holistic interpretation of the Constitution means. The court stated as follows: but what is meant by holistic interpretation of the Constitution? It must mean interpreting the Constitution in context. It is contextual analysis of a constitutional provision, reading it alongside and against other provisions, so as to maintain a rational explication of what the Constitution must be taken to mean in the light of the history of the issues in dispute and of the prevailing circumstances. In the case of Tiny Fuza versus Attorney General, which I've given, citation I've given, the court was of the firm position that the Constitution must be read as an integrated whole, The court observed as follows: the entire Constitution has to be read as an integrated whole, and no one particular provision destroying the other, but each sustaining the other. This is the rule of harmony, the rule of completeness and exhaustiveness, and the rule of paramountcy of the written Constitution. On the tenet that the Constitution does not favor formalistic approaches to its interpretation and that it must not be interpreted as one would a mere statute, the Supreme Court pronounced itself in the case in interim independent electoral commission. The court said as follows: the rules of constitutional interpretation do not favor formalistic or positivistic approaches. The Constitution has incorporated non-legal considerations which we must take into account in exercising our jurisdiction. The Constitution has a most modern Bill of Rights that envisions a human rights-based and social justice-oriented state and society. The values and principles articulated in the preamble, in Article 10, in Chapter 6, and in various provisions reflect historical, economic, social, cultural, and political realities and aspirations that are critical in building a robust, patriotic, and indigenous jurisprudence for Kenya. Article 159, sub-Article 1 states that judicial authority is derived from the people. That authority must be reflected in the decisions made by the courts. Close quote. In expounding the principle that the Constitution has provided its own theory of interpretation to protect and preserve its values, objects, and purposes, the retired Chief Justice, His Lordship Honorable Mutunga, had the following to say in his concurring opinion in the Speaker of the Senate and another versus Attorney General. The Honorable Chief Justice then had this to say: in both my respective dissenting and concurring opinions in the matter of principle of gender representation in the National Assembly and Senate, I argued that both the Constitution 2010 and the Supreme Court Act 2011 both provide comprehensive interpretive frameworks upon which fundamental hooks, pillars, and solid foundations for the interpretation of our Constitution shall be based. In both opinions, I provided the interpretive coordinates that should guide our jurisprudential journey as we identify the core provisions of our Constitution, understand its content, and determine its intended effect. He proceeded to say more, which I have included, but I will not read. The Supreme Court also expounded the incorporation of non-legal considerations and their importance in constitutional interpretation. In the case Communications Commission of Kenya and 5 others versus Rural Media Services, at paragraph 356, the court said this: we revisit once again the critical theory of constitutional interpretation and relate it to the emerging human rights jurisprudence based on Chapter 4, the Bill of Rights of our Constitution. The fundamental right in question in this case is the freedom and the independence of the media. We have taken this opportunity to illustrate how historical, economic, social, cultural, and political content is fundamentally critical in discerning the various provisions of the Constitution that pronounce on its theory of interpretation. A brief narrative of the historical, economic, social, cultural, and political backgrounds to Articles 4, Sub-Article 2, Article 33, Article 34, and Article 35 of the Constitution has been given above in paragraphs 145 and 146. We begin with the concurring opinion of the CJ and the President in Gitirau Munya case, where there was references to Black Law Dictionary, where it was said that references to Black Law Dictionary will not, therefore, always be enough, and references to foreign cases will have to take into account these peculiar Kenyan needs and context. It is possible to set out the ingredients of the theory of the interpretation of the Constitution. The theory is derived from the Constitution through conceptions that my dissenting and concurring opinions have signaled as examples of interpretive coordinates. I'll not read the entire quotation. Then in the case of Center for Rights, Education and Awareness and another, the Court of Appeal also dealt with the subject of constitutional interpretation and laid out the very principles discussed above. The court further recounted the nexus between the principles of constitutional interpretation and the principle of statutory interpretation in the following manner. The principles on constitutional interpretation are not new. They also apply to the construction of statutes. There are other important principles which apply to the constructions of statutes, which, in my view, also apply to the construction of a constitution, such as presumption against absurdity, meaning that a court should avoid a construction that produces an absurd result, the presumption against unworkable or impracticable result, meaning that a court should find against a construction which produces unworkable or impracticable result, presumption against an anomalous or illogical result, meaning that a court should find against a construction that creates an anomaly or otherwise produces an irrational or illogical result, and the presumption against artificial result, meaning that a court should find against a construction that produces artificial result, and lastly, the principle that the law should serve public interest, meaning that the court should strive to avoid adopting a construction which is in any way adverse to public interest, economic, social, and political, or otherwise. The court, as an independent arbiter of the Constitution, has fidelity to the Constitution and has to be guided by the letter and spirit of the Constitution. On our part, we wish to emphasize that the Constitution directs that it shall be interpreted in line with the doctrine of living constitutionalism. The doctrine holds that a constitution is a living document meant to evolve over time to reflect societal changes, contemporary realities, and shifting values. It further recognizes that the law is dynamic and adaptable to evolving circumstances, often encapsulated in the maxim that, in quote, the law is always speaking. It underscores the constitutional provisions as not static or frozen in time, but must be understood as applying to current circumstances regardless of their original context. This interpretive approach ensures that the Constitution remains relevant and effective in guiding the governance and legal framework of a modern, dynamic society. Moreover, the doctrine that the law is always speaking aligns with the purposive approach to constitutional interpretation as endorsed by courts in various jurisdictions. Under this approach, courts are required to interpret constitutional provisions in a way that gives effect to their underlying purpose and objectives, rather than adhering to a rigid or literal reading. Further, courts have emphasized the need for a flexible and forward-looking interpretation of the Constitution to meet the needs of a modern state. With the above interpretive principles in mind, we will now deal with other issues posed in the application under consideration.
I will deal with the second issue on whether the DCJ can assign judges pursuant to Article 165, Sub-Article 4 of the Constitution. There is no doubt that this was the most contested issue in the subject application. Article 165, Sub-Article 3 and Sub-Article 4 of the Constitution provide for impanelment of benches of an even number of judges as follows. Permit me not to go through that. In dealing with the above issue, courts have taken two diametrically opposite positions. One of them being that the assignment of judges is a constitutional duty which can only be undertaken by the Honorable Chief Justice. As such, the Honorable DCJ cannot assign judges under Article 165, Sub-Article 4 of the Constitution. The other position posits that although the duty to assign judges is provided for in the Constitution, its implementation is administrative, and that duty can be undertaken by the Honorable DCJ. In Kenya Medical Research Institute versus AG, which was a 3-judge bench of this court, held as follows. They quote paragraph 37. Therefore, by empaneling this bench, the Chief Justice was carrying out his constitutional mandate as opposed to similar functions under the former Constitution, which were hinged on the constitutional provisions and were merely administrative. End of quote. In Leina, Conchela, and others, which was a 5-judge bench of this court, the court went ahead and described the role of the Chief Justice under Article 165(4) as constitutional as opposed to a merely administrative function. It also said, it is our view that a constitutional mandate of the CJ can be judicial, administrative, or political, and the current Constitution does not indeed state that the Chief Justice is the head of the judiciary which embodies all these functions. The learned judges in that empaneled bench then found that the constitutional mandate exercised by the CJ under 165(4) of the Constitution is an administrative function. The court also elaborately dealt with the issue as to whether such an administrative function could be undertaken by the Honorable DCJ, and in the end, the court rendered itself as follows. I quote paragraph 78. It therefore our finding that constitutional function of the CJ to assign benches under Article 165(4) being an administrative function can be performed by the Deputy Chief Justice when the Chief Justice is for good reason unable to perform. End of quote. The petitioners in these matters also cited the decision in Okoiti versus JSC and another, which is constitutional petition number E408 of 2020, as buttressing the position that the assignment of judges is a constitutional mandate and the sole preserve of the Honorable the Chief Justice. The decision was delivered by yours truly, who is part of this expanded bench. We have carefully considered the said decision. One of the issues therein, which may be said to have a bearing on this matter, was whether the Honorable CJ could rely on Section 5, subsection 4, and subsection 5 of the Judicial Service Act to authorize the Honorable DCJ to serve as the acting Chief Justice when the Chief Justice was proceeding on leave pending retirement until when a succeeding Chief Justice was appointed. As the matter did not deal with the nitty-gritties of the aspect of assigning of judges, but rather the constitutionality of the actions of the CJ who was exiting service, we respectively find that the issue is not at par with what is under consideration in this instant application. The said decision is hence distinguishable. Returning to the matter at hand, it is imperative to look at the various terms which come to play in this matter, including the administrative actions as well as judicial actions. We have gone through that. I do not think there is need for me to read all that. It's in the ruling, and I proceed to state that from the above discourse, we do not find any difficulty in affirming the position that a constitutional mandate of the Honorable Chief Justice can be judicial, administrative, or political. We further find and hold that the constitutional mandate exercised by the Honorable Chief Justice under Article 165, sub-Article 4 of the Constitution, is a constitutionally administrative function. We shall now consider whether the function of the Honorable Chief Justice under 165, sub-Article 4 of the Constitution can be performed by the Honorable DCJ. Article 161 of the Constitution establishes the office of the Chief Justice as the head of the judiciary, and that of the Deputy Chief Justice as the deputy head of the judiciary. Article 163 of the Constitution creates the Supreme Court and designates the Honorable Chief Justice as the president of the court. The Deputy Chief Justice is to deputize the Chief Justice and is also the vice president of the court. Article 171 of the Constitution establishes the Judicial Service Commission, or the JSC, as one of the Chapter 15 commissions. The Honorable Chief Justice in JSC is the chairperson, and in this scenario, and unlike the constitutional architecture in Articles 161 and 163, the Honorable DCJ is not the vice chairperson of JSC. Running alongside the foregoing are the functions of the Chief Justice and the Honorable DCJ as provided for in Section 5 of the Judicial Service Act. The provision states as follows. This is in respect to administration of the judiciary. I do not need to read through all that. I proceed to say that the decision in Lena Conchela also dealt with the definitions and various types of deputies, and ultimately rendered itself in the following manner. I think this one I should quote. Paragraph 77, it says, it has been canvassed before us that where the Constitution intends the Deputy Chief Justice to act on behalf of the Chief Justice, it has expressly stated so. Specific examples cited were Articles 141.1, 144.4, 148.4. These provisions fall under Chapter 9 of the Constitution that deals with executive. This chapter does not have a general provision as regards the deputization of the Chief Justice by the Deputy Chief Justice, as is provided for in Article 161 2b in Chapter 10 of the Constitution on the judiciary. Hence, the provision of the deputization of the Chief Justice in Chapter number 9. A holistic and purposeful interpretation of Article 161 2b of the Constitution and Section 5 of the Judicial Service Act leads us to the conclusion that the Deputy Chief Justice substitutes the Chief Justice where necessary. End of quote. In the end, the learned judges found and held that the constitutional function of the Honorable Chief Justice to assign benches under Article 165 for the Constitution, being an administrative function, can be performed by the DCJ when the DCJ is, for good reason, unable to perform this function. On our part, we have carefully addressed our minds to the issue. We find that there was a deliberate scheme by the drafters of the Constitution for the Honorable DCJ to deputize the Honorable CJ as Deputy Head of the Judiciary and as the Vice President of the Supreme Court, but not in the JSC. Such was an emphasis on the various manifestations of the constitutional duties bestowed upon the Honorable Chief Justice and the Honorable DCJ. As such, the prevailing legal position is that the Honorable DCJ can deputize the Honorable CJ in discharging judicial functions and in the administration of the judiciary as an arm of government, but cannot do so in respect of the affairs of the JSC. Our attention has also been drawn to the provisions of Article 259, Subarticle 3b of the Constitution, which states as follows. This refers to construing the Constitution, and Subarticle 3 provides as follows. Every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore, among other things, b, any reference in this Constitution to a state or other public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing the functions of the office at any particular time. Emphasis, or otherwise performing the functions of the office at any particular time. The above provision creates three tiers in which constitutional functions can be exercised. That is, by the substantive office holder, or by a person in an acting capacity, or by a person otherwise performing the functions of the office at any particular time. In our understanding, and against the background of the doctrine as stated, the drafters of our constitution were deliberate about ensuring that the administration of duties and the application of the constitutional provisions are continuous and seamless, recognizing the necessity for offices and their functions to be performed even in transitional or extraordinary circumstances. Such an interpretation avoids technicalities and vacuums that could disrupt the functioning of state officers of public institutions, thereby promoting administrative efficiency and upholding the principles of constitutional governance. The provision reflects the broader principles of the rule of law and good governance, which require that state and public officers continue to function effectively, even during periods of transition or when the substantive office holder is unavailable. It in turn promotes legal certainty and administrative efficiency by ensuring that all constitutional responsibilities are carried out without disruption. For this reason, the functions of Article 165, sub-Article 4, in our view, and in as far as the same relate to the office of the Chief Justice, also includes the Deputy Chief Justice acting in the capacity of the office of the Chief Justice or discharging its functions in an interim, acting or auxiliary role. At this point in time, we also wish to point out that the Honorable Chief Justice empaneled this very bench on the 14th day of October 2024 to deal with 6 constitutional petitions that inter alia challenged the first petitioner's impeachment process in the National Assembly. The said petitions are still current. On the 18th of October 2024, the Honorable DCJ empaneled the same bench to deal with constitutional petitions challenging the impeachment of the first petitioner in the Senate. To us, it is beyond peradventure that the Honorable DCJ can assign judges under Article 165, sub-Article 4 of the Constitution, whenever he or she is discharging any of the constitutional functions on behalf of the Chief Justice. In this case, we do not find any fault in the Honorable DCJ assigning judges to sit in this bench, more so when the Honorable Chief Justice has not raised any red flag. Thank you.
Right. I will deal with a question of other related issues that came up during the review of the benches and panelment by the Deputy CJ. Several additional issues have been raised. The bench found it necessary to address these issues so as to ensure both the completeness of the record and finality in the issues raised. During the submissions, an issue was raised concerning the directions issued by the 3-judge bench and the transmission of the files in Nairobi Petition E565 of 2024, Kerugoya Petitions E013 and E014 consolidated, as well as E015 of 2024. A review of the CTS, that is a case tracking system, confirms that the petition in E565 of 2024 was filed on the 18th of October 2024 at 8:00 a.m. Later that same day, approximately 5 hours on at 1:51 p.m., Justice Chacha Muita dealt with an application filed under certificate of urgency which had been submitted alongside the petition. By 5:33 p.m., roughly 3 hours after the earlier application, a notice of motion application dated the 1st of October 2024, it was dated the 1st of October 2024, was filed, this time by the respondents seeking the following orders. 1, that the application be certified as urgent and service of the application be dispensed with in the first instance, 2, that pending the hearing and determination of that application, inter partes, this honorable court be pleased to set aside, vary, or review the orders issued on the 18th day of October 2024, that is the interim conservatory orders. 3, that in the alternative, this court be pleased to set aside, vary, or discharge the ex parte orders issued on the 18th day of October 2024, and 4, that this honorable court do issue any other orders it deems fit in the interest of justice. Following its empanelment on the 18th of October 2024, and having received directions from the Office of the Deputy CJ, the bench deliberated on the appropriate directions to be issued. On the 19th of October 2024, at 12:20 p.m., the bench issued the following directions. That in light of the urgency of the matter and the weighty issues raised therein, we direct that the application be served and responded to forthwith for hearing inter partes on Tuesday, the 22nd of October 2024 at 11 a.m. in open court number 18. Petition E013, on the other hand, was filed on the 25th of September 2024 at 8:33 p.m., while petition E014 was filed on the 2nd of October 2024 at 7:07 p.m., both way past official working hours of the court. The CTS will further show that an application in E014 was filed on the 30th of September 2024, and directions were issued on the very same day, although the matter was not certified as urgent. Subsequent directions and a ruling issued on the 11th of October 2024 resulted in the consolidation of petitions E013 and E014, followed by an order for empanelment. As the record on CTS will further show, the directions issued by the court in E014 of 2024, which were issued on the 2nd of October 2024, were again issued at 6:22 p.m., which is outside of what one would call the routine working hours of the court. This was due to the urgency demonstrated in the application, which sought directions regarding the then ongoing public participation process. The bench takes great exception to the petitioner applicant's conduct that when favorable to them, issues of orders, rather orders issued outside of what one would refer to as the normal working hours of the court raise no concern. However, when the court acts in an instance where it has been moved by any other party and likewise proceeds to deal with an application at hand, the applicants show their indignation. Moving to petition E015, the CTS again would show that the same was filed on the 18th of October 2024, and once again following the directions issued by the court, this bench was empaneled on the 18th of October 2024 to hear all the three petitions, that is E565 of 2024, E013, E014, and E015, all of 2024. From this sequence of events, it is notable that the interaction between counsel and the courts on an almost real-time basis is not novel, and is in fact a practice that counsels are well familiar with. The CTS enables both counsel and the court to operate in real time, transcending traditional time limitations. This fact also buttresses the argument that with the advent of the CTS system, it is not unusual for courts to issue directions within the filing of an application or outside of what once again would be referred to outside the routine work hours of the court where circumstances do so require. Moreover, in raising the issue of improper seating, the applicants omitted a crucial fact, which was that the court had been moved by the respondents in petitions E565 of 2024 and E015 of 2024. As such, the court did not convene suo motu, but rather in response to the applications before it. The applicants have repeatedly referred to this convening as a sitting of the court, a term that we feel as a bench requires clarification and demystification. It is a matter of judicial notice that since the onset of the COVID-19 pandemic and the introduction of the case tracking system, the tradition of dealing with certificates of urgency has since evolved. Allow me to quote the practice direction number 19A of the High Court Practice Directions of the 11th of January 2022, which states as follows: that applications filed under certificate of urgency shall be considered by the judge, we emphasize here, at the earliest opportunity. While the practice directions also stipulated that applications filed after 12 p.m. may be considered the next working day, the full adoption of the e-filing system across the judiciary has largely rendered this provision obsolete. Applications are now processed almost in real time, a fact well known to the justice users across the country and which we have demonstrated in this ruling. Furthermore, Practice Direction 19B confers discretion upon the court to issue orders or directions without the attendance of advocates or parties. This implies that the court can indeed issue directions on an application without the need for a formal sitting. The relevant provision once again reads as follows: that the court may, in its discretion, issue orders, stroke directions without the attendance of the advocates or parties. I end quote. In this case, the issue has been raised that this court allegedly sat and considered an application by the respondent on a Saturday outside of the official court hours. The ordinary definition of a sitting, as provided in the Black's Law Dictionary, is a formal occasion when the court convenes to conduct its business. In this instance, no such formal sitting occurred. In this instance, may I repeat, no such formal sitting occurred. Rather, the bench merely conferred and issued directions electronically as expressly permitted under Practice Directions 19B. This is markedly different from a court session in which the bench is convened to hear and determine a matter. Furthermore, no evidence or proceedings have been presented before this bench to support the claim that a formal sitting did take place. Accordingly, it is only fair and reasonable for the parties to dispel any notion that this bench convened to hear arguments from any party ex parte that this bench convened to hear arguments from any party ex parte before issuing directions. No such formal sitting took place, the court again emphasizes, and directions were issued electronically in line with established practice and procedural rules. We do, however, recommend that the current practice directions and relevant statutes, such as the High Court Organization and Administration Act, be amended so as to provide a much needed further clarity on this subject. Moreover, for the avoidance of doubts, and out of all the prayers sought by the respondent, only prayer number 1, which sought to have the matter certified as urgent, was granted. No other reliefs were considered or granted at the time. It is evident that the court was fully cognizant of both the urgency of the matter and the potential repercussions that granting any further ex parte orders could have had on the prevailing status quo. With this understanding, and in an effort to balance the scales of justice, the bench issued the directions that are now being challenged. We hold the view that there was nothing unconventional in the manner in which this bench dealt with the 2 applications filed under certificate of urgency. As regards the argument that directions had already been issued by the respective courts for a mention before the bench on the 24th of October 2024, the arguments by the applicants appear to insinuate that the bench ought to have retained the date. For clarity purposes, this date had not been given by this bench. Rather, this date had been given prior to the empanelment of this bench. However, upon empanelment of the bench, the applications under certificate of urgency, the ones that I have just referred to, were filed, which applications were dealt with, and we feel rightly so. Being seized of the matter, it is our view that the bench retains the discretion to issue appropriate directions depending on the developments and in light of its mandate as it did, having been moved by a party under certificate of urgency. With respect to the claim that was raised on discriminatory transmission of files to the bench, it must be emphasized that this bench has no role and no control whatsoever in the administrative processes that occur prior to its empanelment. Concerns have been raised about delays in the transmission of certain files, but it is crucial for us to clarify that the term transmission in this case may not necessarily refer to the physical transfer of documents. In the context of judicial processes, particularly with the advent of digital systems, transmission may very well refer to the electronic movement or assignment of case files within the judiciary's digital infrastructure. We say this on the strength of the fact that with the CTS, all filed documents are available in real time across the judiciary, eliminating the need for physical file movement. Let me refer once again to practice direction number 41A Roman 2, which provides that advocates and litigants shall have access to court information electronically. While this court cannot and will not speculate on the causes of any delays in file transmission, the bench nonetheless finds no basis for concluding that such delays amount to any form of procedural omission on the part of the bench, as no such evidence has been presented. The applicants have equally in their submissions attempted to cast aspersions on the proceedings of this court, some of which I have already referenced. That is that the court was convened on a Saturday, stating that there is no urgency in this matter, and so there was no need to convene the sittings of the 22nd day of October 2024, that this matter is being given priority over other petitions which have been filed, an insinuation that the bench is part of a conspiracy to infringe the petitioner's Article 50 right to fair hearing, And what I have again alluded to, that the transmission of the files from the Kirugoya High Court took place with what has been referred to as a supersonic speed. One of the counsels went further by intimating that an exercise akin to the radical surgery may well be forthcoming, a statement which the bench, with tremendous respect, perceives as a veiled attempt at intimidation. The bench feels that such remarks are regrettable and wholly inappropriate. This bench remains firm in its duty and will not be swayed or influenced by any form of intimidation, regardless of its source. The bench takes the view that the applicants appear to selectively focus on aspects that favor their position while conveniently disregarding that the clients that the applicants are presently benefiting from final conservatory orders, which this bench did not deem it fit to lift. Despite having obtained final conservatory orders, as the court has already observed, it is now apparent that the applicants no longer perceive the urgency in this matter. Instead, they seek to cast aspersions on this court for addressing the matter with the necessary expedition. Such conduct is contradictory and undermines the very urgency that the applicants had initially invoked. The bench notes that the issues raised in this petition have on various occasions and before different judges consistently been certified as urgent and as involving substantive constitutional questions. This underscores the gravity and significance of the matters at hand. One of the counsels again insinuated that this bench is part of a conspiracy to violate the petitioner's right to a fair hearing under Article 50 of the Constitution. The bench finds that these submissions are without any foundation and wholly without merit. This court has not issued any rulings or directions that would suggest such an intention. It is apparent that this argument was made for the sake of the gallery, and we find it unnecessary to therefore address it further, save to reaffirm that this court remains fully committed to upholding the Constitution and the rule of law. In conclusion, we do find and hold that the accusations made by the applicants against this bench are entirely without merit. On this link, the last part of the link is whether the matter raises issues of public interest which require expeditious disposition of the petitions. The applicants have urged that the applications before the court are not urgent and have loudly wondered why it was necessary to give directions for hearing of the applications on the 22nd day of October 2024. In response, the bench quotes Article 131, which establishes the office of the President and the office of the Deputy President, and also we have cited Article 147 with regards to the functions of the Deputy President, just to lay context. And the context is this, according to the bench, that the first petitioner has been impeached under Article 145 of the Constitution, marking the first instance of such an event in Kenya's history. The impeachment of the said petitioner has undoubtedly garnered significant public interest, and these court proceedings represent a direct challenge to that impeachment. It goes without saying that these legal proceedings are of paramount concern to the citizens of this country. To suggest, as the applicants have, that this matter lacks urgency and does not warrant prompt adjudication is disingenuous and dismissive of its far-reaching implications. We have taken the liberty to define the term public interest in the Black's Law Dictionary, and you will also find the Supreme Court of Kenya's definition of public interest in the case of Stewart versus Roscoe, which permit me not to get into. Safe to say that from the foregoing, a matter is of public interest if the holding on law affects a considerable number of people in society, if the holding in law involves government and or government agencies, if a determination of law affects the proper functioning of public institutions of governance or of the court's scope for dispensing redress, and if the holding of law affects the mode of discharge of duty by public officers. These proceedings, in our view, as the bench, raise enormous public interest, and it is in the interest of that public that these proceedings are heard and finalized most expeditiously. Therefore, the aspersions cast by the applicants concerning the directions for the hearing of the applications before the court on the 22nd day of October 2024, in our view, lack basis, and they are dismissed. I thank you.
Disposition. Having carefully considered the application, we are satisfied that the prayers sought herein must fail. Nonetheless, as indicated in our ruling, there is a pressing need for a clear practice directions regarding the procedure and the process for handling virtual and online directions and proceedings. We commend the applicants as this application has illuminated the necessity for such guidelines and made the issue more apparent. As such, we hereby direct the Honorable Deputy Registrar of this division to transmit a copy of this ruling to the Honorable Chief Justice. Before we conclude, the bench wishes to once again emphasize its unwavering commitment to objective neutrality in this matter. We assure all parties that their right to a fair hearing remains fully safeguarded. The bench, acting in fidelity to its oath of office and in strict adherence to the dictates of the Constitution, remains resolutely committed to the fair and just determination of the issues before it. Finally, the application dated 22nd of October 2024 is disallowed with costs in the course. Leave to appeal is hereby granted. Certified copies of these proceedings and rulings shall be availed upon payment of the requisite court fees as the case may be. That's the ruling of the court.
My lord.
My lord, on behalf of the petitioners, we have listened to the ruling. We have got no problem with the feasibility of it one way or the other. We leave it to our clients, the decision on whether or not they will appeal the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never uttered. Be that as it may, I believe since we received some communications from the Deputy Registrar, and there were certain other pending matters in the files that were under consideration, we shall await the directions of the court before, from the petitioner's point of view, we can say one or two things. I do not know whether our business as Mailani Senior on which has anything to add.
My lords, your leadership, we appreciate that this honorable court of its own volition has granted leave to appeal. Speaking for myself, obviously the decision is that of the client. So I will be advising the client, but it is for the client to make the final decision. But in fairness to me as counsel and other counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this court. It is damaging to counsel, and that is an issue that definitely needs to be taken out of the record of this court by the Court of Appeal. It was a very unfair accusation. Thank you.
May it please the court, on behalf of the respondents, we thank you for the timely nature of the delivery of that ruling to allow this matter to proceed. We note that you have permitted the parties leave to appeal, and we support that. The respondents support a fair resolution of this dispute in accordance with the law, and therefore we would not oppose their right to appeal. Having said that, however, and in reference to my learned friend, Mr. Kibe Mungai, who has alluded to other petitions pending before, it is the respondent's position that we should exhaust all matters today relating to the matter that has been called out by your clerk or your legal assistant. I apologize to the lady, so that we may exhaust that, after which the court will give directions on any other matter that may be before you or may be anticipated to come before you. We thank you.
My lords, my lady, on behalf of the National Assembly, I wish to express our gratitude for the very clear ruling that the court has delivered this afternoon. The ruling has dealt conclusively, not just with the matters that were contained in the application that was hurriedly filed and responded to yesterday afternoon, but indeed some of the other peripheral issues that the petitioners unfortunately took a lot of court time yesterday to deal with. My lords, my lady, the National Assembly has filed an application dated the 18th of October 2024. And I believe that application was referred to in the ruling a few moments ago. That application, subsequent to the ruling that you have just delivered, I submit is the next issue that the court should deal with. And just to put it on record, my lord, that we are ready to proceed with that application this afternoon. Members of the court will recall that last week on Tuesday, on the 15th of this month, at an hour not very different to this, when it suited the petitioners to have their application for conservatory orders heard, they insisted on it being heard. And we request that the urgency in this matter remaining and having been noted by the court, we proceed with the hearing of that application, which has been fully responded to immediately after this. I'm most obliged.
My lords and your ladyship, further to that, for Senate, I wish to state, my lords and your ladyship, that unlike the petitioners, we are willing to argue the application in a record 30 minutes.
Is this the same application?
Yes, the application dated 18th October 2024. We will only ask for 30 minutes to exhaust our application. We will dive straight into constitutional principles. We will not take much time. The respondents can have as much time as they want so that this matter can be concluded. My lords, Mr. Kibe has talked about the gallery of Paul Mwite Senior Counsel. From that side, it was apparent that they were not just addressing the court. They were addressing other matters.
Do we need to
Let us not go into that.
Do we need to engage in
Professor,
arguments on that?
Let us not go into that now.
I will withdraw that.
Yes.
But my Lord, we are ready to proceed. 30 minutes.
No, we don't want you to raise something and then you say you withdraw it. After causing the damage.
It's okay, my Lord.
we withdraw properly.
It's okay, my Lord. My Lord, I will withdraw the remark that the petitioners are addressing the public gallery today. Most obliged.
My Lord, my Lord, with your permission, my lady, yesterday we were barred from being part of these proceedings. We have seen communication that we are now legally here. We have stopped the morning. Could we be allowed officially by these files being called so that we are together? We still feel that we are excluded when we are before you.
In which
Our
petition?
files,
In which petition?
There is petition 5, E570, okay. E550, E541, E572 that are supposed to be before you. That we complained to the CJ in the morning, and the CJ has directed we appear here and be part of this mosaic. Kindly let us be part of it.
Your Lordship, equally, I rise as the advocate appearing in E509 and associate myself with the submissions made by my learned senior counsel, Paul Moiten, and the ones made by my learned friend, Senior Given. Your Lordship, to the best of our knowledge, in the matter E015, when we broke yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday I indicated to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated, and now E565 consolidated. And we have been issued the notice that my learned friend Mr. Omari is referring to, that he also seized of 4 other matters: E570, E550, E541, and E572. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in respect to those particular files. I hope the court is in possession of this notice, so that the court may refer to the same. Subsequent to which, Your Lordship, will be seeking your guidance on how we deal with the applications filed therein. For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We wish that subsequent to the court addressing and acknowledging that the other files before it, that I get directions on how to dispose of my application, for which, Your Lordship, the application was served. I wish to take directions exclusively and specifically on that particular matter.
My Lord, may please, I hate to interrupt, but this is most unproceded. We are all counsel of some reasonable experience. We all appreciate, some of them here are very senior advocates, very senior counsel. The file before the court is the only file in which you can make an application. The court cannot make orders in files that are not before it. All these files physically brought to the court are not before court. They will be before court when they are called out by your legal assistant as being available for the court to make orders. We therefore object to this manner of conducting these proceedings. It is our very humble submission that it is yet another attempt to delay the expeditious disposal of this matter.
Your Lordship, very
my Lord, if I may, my Lord. Yes. There are matters that you have certified as urgent, and that you have identified as being urgent. And I say this with a very heavy heart. My learned colleagues for the petitioners have been engaging in this dilatory tactic since yesterday. There are 2 applications before you that are certified as urgent. There are several other matters that have applications that perhaps have not been certified as urgent. Perhaps your lordships may be kind enough to deal with those urgent applications, and these matters can be dealt with later on. The files may be here, but they're not before the court.
Yeah, your lordship.
Okay, you have talked enough.
Council on this side they have.
Yes.
Council on that side appears to be taking the whole of it.
Because they stand
Please,
much.
please.
Just speak, Mr. Mute. If you want to be heard, just speak. We'll listen.
My Lord, I'm asking
Yes.
for equity of power.
We
All time to council on this side.
they stand and speak. You also just stand and speak. We have no
Stand, my lord.
Yes, speak.
My Lord, I think for purposes of clarity, yesterday, when we started hearing on the issue of validity of the bench, which has now been disposed by the ruling in bread, the question that they wanted was the application for the validity plus the issue to do with the recusal be heard together. The understanding of the court and ourselves was that they cannot be dealt with together. So that the second preliminary issues after the issue of the validity of the bench has been disposed of are the 3 pending, I think, actually I know about 3 applications for recusal. Those are preliminary issues and they relate to the same consolidated matters that this court has given a ruling on. That is issue number 1. Issue number 2, my lord, that is important to be noted. Yes, the consolidated file that is before you has that applications for recusal. That's what my learned colleague is emphasizing. So the second business of the court was supposed to be that one. But more importantly, my lord, so that we do not want to hear these accusations about, oh, somebody is trying to delay this matter. We are the victim, and I reiterate that. For purposes of the petitions before you, we would like this petition heard as of yesterday. And we kept on saying yesterday, the petitions to be heard. My lord, these rules, because it's the enforcement of the constitutions, the Mutunga rules applies. Since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond even to the petition to get the matters rolling. There have been no compliance with Mutunga rules for purposes of the respondent. So that if anybody was to be accused of any delay, it would be somebody who has not complied with the Mutunga rules. That is issue number 1. Issue number 2, my lord, was this, that even for purposes of consolidation, the consolidated matters, some of the advocates led by my colleague, Ms. Kimoto, they were not even served with the applications that the respondents are itching to have them disposed of. So that, my lord, because of that mess that was created as of yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situations where some of the advocates in the 4 matters that were not there yesterday have not even been served with this notice, and I know them. So that unless now we take a fresh date without somebody waiting to say that, oh, this court must discharge orders and we have a swearing in over the weekend, the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, oh, I want to lift the conservatory order and the other side is delaying, it is unfair. We want the petition heard, and it starts with compliance with the Mutunga rules, which there is no compliance whatsoever by the respondents. So that, my lord, I beg you that let us not appear now to be saying, oh, somebody is playing to the gallery. Nobody is playing to the gallery.
We just want to assert everybody's rights. And these rights are very easy to enforce if the Mutunga rules are going to guide these proceedings. My Lord, I beg you to have the enforcement of that.
Your Lordship, I had just wanted to highlight the content of the notice which you received.
I think we'll talk about the notice. Just sit down. We want to talk about that notice.
Your Lordship,
I will talk about that notice before you speak.
Your permission to address the court?
Yeah, even if the court wants to talk, you don't want the court to talk. Dr. Camino, let me address the issue of the notice.
Oh, sorry. I apologize.
Yes.
I apologize.
I think we have made it very clear in the ruling which you have just delivered that the matters before this court are very important to the people of this republic. And you will appreciate that petitions are still being filed throughout Kenya. When we retired yesterday, we received several empanelment of matters of which we gave this notice. Therefore, don't think you are the only person who are in these petitions. There are also other Kenyans who are coming day in, night out. So the matters which you've set out for mention are the matters in which we have been empaneled as from yesterday. So you wait for court to give directions, then you start talking. You cannot just start talking from the air without facts. Let us mention these files first. Then from there, you'll see the directions emerging, and then you can make your prayers. Let's mention these files first. The other clarification is that we have two cohorts of petitions which have been consolidated. The first cohort were the petitions which were filed to challenge the processes both in parliament, yes. And during that time, this bench consolidated 6 petitions, with the lead petition being 522 of 2024. Is that correct? That petition, number 522 of 2024, is the lead file in the petitions which were filed before the finalization of the matters in the Senate. Then, after the proceedings in the Senate, other petitions were filed, and with running parallel petitions before the Senate proceedings and after the Senate proceedings. You will remember that petition number 522 was, we listed it for a mention on 29th of this month. But because of need to know, because I know there could be cross-cutting representation in these petitions, we decided just to call it because we knew that all of you would be here, so that if there's anything you want to say on those petitions, you can say it. So that's the reason why we have petition 522 here for a mention. There's nothing to be mentioned, but we said since parties are likely to be here, and some of the parties were even asking for it yesterday, so we brought it. But the other petitions to be mentioned are specific petitions where we have been empaneled. And we wanted to find out the way forward, whether we can consolidate these petitions or whether they can be done separately. So these are petitions number, let's mention petition number 570 of 2024, A.D. Waiguru and Victor Gatia. Yes, this petition. Yes.
My Lord,
That's a minute.
Yes.
My Lord, in this petition, this one was filed by the law firm of, I believe, Mutembei and Marek, it's called what? Mutembei, Geshoro and Company Advocates. I am aware of this petition for the simple reason that he had requested me that when it comes to the hearing, I appear alongside him.
Alongside who?
Mr. Mutembei Marete. My Lord, the parties are many, starting with the first respondent, I think is President Ruto, regarding Gachagua is the second respondent, and there are others. My Lord, for purposes of this petition, it was filed after the. For purposes of this petition, it was filed after the on Friday, and by Judge Mamuye, referred it to the Honorable Chief Justice, and we expected it to be coming tomorrow on Thursday. My Lord, Mr. Mutembei was not served with this particular notice that is before you.
Actually, nobody was served. We sent out the notice in the morning today because
Yes.
we received them in the morning.
In the morning.
And that's why I said that this matter is coming.
Yes.
And because the representation is likely to be across, we
Yes.
mentioned them because we thought we'd find people like you waiting
Yes,
for them here.
Waiting for them here.
Yes.
So that, my Lord, in that case, what I would ask the court, and for the additional reason that I am aware that in that matter, the notice of motion is seeking a 5-judge bench, and particularly for the reason that this is an application by the citizens of Central Kenya who says, like in the year 2013, that their rights, not just regarding Gachagua, have been affected adversely by the impeachment of the Deputy President Gachagua, and therefore I would ask that this matter do come tomorrow so that the issue on that issues of empanelment and in the presence of Mr. Mutembei can be dealt with. Because now that it is obvious that even the direct, like the advocates who filed the case are not here, it would only be fair that there is another mention where they can also be there. Actually, we didn't even have the file. We are just looking at it from our record. But that is the position as far as 570 is concerned. There is a specific application for a 5-judge bench in that matter.
Mr. Kibe.
Yes, Lord.
We are beyond that. There was a request for a 5-judge bench,
yes,
but what has been empaneled is a 3-judge bench, yes, comprising Justice Eric Ogola, Justice Mrima, and Honorable Dr. Justice Freda Mugambi. So the request for a 5-judge bench, I think, is overtaken by events unless he wants to appeal.
Yes. The chances of appeal are very high. for the simple reasons, my Lord, that will become apparent. I believe there must be some mechanical applications to the issues, but now that it arises specifically, that issue would be addressed, and the Chief Justice would have the relevant communications tomorrow morning, while given the nature of the issue that must be dealt with, there must be a 5-judge matter. All benches can be expanded. I believe that is the position that we are coming from. So without saying specifically that we don't want anyone, all benches are capable of being expansion, particularly bearing in mind, and this is something that a number of the clients that already we are representing, there have been repeated insinuations by our people out there, including Senior Counsel Benazir Abdullahi, that the senior bench is supposed, the 3-judge bench is supposed to do this or the other. We can't help that. This is not coming from the petition.
What we'll do, Mr. Mugai, is that we'll mention this matter tomorrow.
I'll appreciate. What time, my Lord?
At 9.
Most obliged.
Mr. Kibe, you will serve.
Most of the people actually here, we have served them, but we shall serve the notice of hearing.
All right.
The notice of hearing for the mention tomorrow at 9. I thought, my lord, the 10 would have been easier, because by the time I go to my office, there will be nobody to do some of these things. Or probably 11.
You know, but the time we spend here means that even if you come at 10, you'll find us here.
My lord, what time then do we come tomorrow?
The court starts at 9.
Yes.
You can come at 11.
11. What's the
Yes.
My lord, I am asking, please, in this particular file, that you record my presence together with the other lawyers I mentioned earlier as appearing for the deputy president with the second respondent.
This one?
Yes.
The verified?
Yes.
But you didn't stand up, Mr. Mute. I thought you were not here. This matter of 570?
Yes. If you look at the party, the deputy president is the second respondent.
So you agree with the directions which you have given?
I accept directions. And I will be here tomorrow at 11. Inshallah.
Please, Your Lordship, in this particular matter.
Let's the same matter?
Yes.
570?
Yes, my name is Manzo. I'd wish to go on record for the first interested party.
Your Lordship, my lady, may I be placed on record for the second and the fourth interested party? And permit me to only indicate the implication of the orders of the impanelment that were issued by the judge who directed the Chief Justice does impanel you. To the best of my thinking and knowledge is that the prayer was granted as it is for the impanelment of five judge bench.
Mr. Jiro, yes.
They want Jiro.
We speak from the record. You had me mention the parties. I said that this file has been empaneled to comprise the Honorable Mr. Justice Eric Ogola, the Honorable Mr. Justice Murima, the Honorable Dr. Judge Freda Mugambi. I think that's very clear. We are only three.
That's correct. But okay, I will address you tomorrow on that issue.
My lords, my lady.
So we mention it tomorrow. Mr. Njiru, you say you come for which parties?
Your Lordship, I appear for the second and the fourth interested party.
Thank you.
My Lord, perhaps if I may make a request. My Lord, there is a file that is live before you. And that is petition number 565 of 2024. We have requested, my Lord, that you give directions, because this process of taking quorum might take some time. And there are 3 cohorts of files that are before you. And if I may.
All right. Very quickly. Okay, so what's basically happening for those who are still wondering, who just woke up or live under a rock? This court has pronounced itself and says, ruled that they are actually going to preside over this case, impeachment case, They gave examples of, you had the judgment, the ruling. It was such a long-winded response, but the basic thing is they were arguing that, Chief Justice role in this matter can be administrative. And so Deputy Chief Justice Mwelu acted constitutionally, could have and lawfully impanel them to, preside over this matter. And also they mentioned that initially they were the ones who picked to deal with the petitions that the Brigadier Gachagua's lawyers put in initially. So they see nothing wrong presiding over this case. So they will be presiding over this case. But as you had Mwite and Paul Mwite and the other lawyer who say there's high probability that they will appeal that decision. Okay. And it's so funny because Abdi Nasir made this point, and I will read his tweet just one more time because it seems like everything he said is going to happen. And Abdi Nasir, if you do not know by now, he's very vocal about judicial reform. And I mean, he's cries every day on Twitter talking about how the judiciary is corrupt. I do not doubt him. This man made his billions by taking cases and bribes and all that stuff to win big cases. So he knows the system, how it works, and he says it's rotten to the core. And to be honest with you, I never really trusted Kwame from the get-go. The whole, yes, there are some, I'm not saying everyone at the judiciary are corrupt, but for the majority part of it, I mean, if you look at this ruling, now some people are saying, oh, Justice Mwilo acted constitutional. If you see the nature in which they did this, that's what's questionable. Why did you have to, do things on the weekend? And the petitioners were not notified. Okay, then they argue, oh, you know what? You can always log into the system because they have an e-filing system. They have a name for it, I forgot. So they were arguing, oh, the notification was done on the e-system, so you should have logged in there and find out if the notification was there. But again, who does that on the weekend? I mean, weekends is when people rest. So again. Then there's those people who argue that the petitioners, the Rigathi Gachagua and the gang, are wasting time. Wasting time for what? Like, why are they buying time? Like, what do they gain by dragging this? That's the whole. To me, I find it a little bit silly for somebody to say, "Oh, the Rigathi Gachagua is buying time. Okay, he's buying time for what? To do what? What is he gaining? If it's clear that he's going to be impeached and Kindiki is going to be forced into that deputy president position, why? What is wasting time? Delaying? What does delaying help? How does delaying these cases, stretching it out as far as time is concerned, how does that help Gachagua? That's the argument that I just don't understand among a lot of people who are making this argument. It's not beneficial for Gachagua to stretch this thing, okay? I'm Saidi. Delay for what? How is that helping him? If he knows that he's no longer the deputy president. He's, the seat is vacant. So how does that help him by delay? So this delay argument is stupid, to be honest with you. But again, let's not lose focus. This is not a pro Gachagua position that I'm taking. I'm pro justice. The nature in which the National Assembly and the Senate and now judiciary are going through this thing, I'm not buying it. I don't think justice is done, especially in a weighty issue as such, an impeachment of a deputy president. They should be accorded enough time. Okay, just like Kaminwa said yesterday. Why are we in a hurry? Where are we going? Why such a hurry? Yeah. Now, you had the petitioners say that they will be appealing and requesting for a 5-man bench. and that argument will be made tomorrow. I think the arguments now we'll be hearing about the main arguments of the of the impeachment and the process while that is happening. And I'll take you back to that, to the proceedings, so we can hear the lawyers. It's just kind of, there's like a bunch of lawyers who have to talk, and they're kind of saying the same thing, and it's like, anyway. We'll go back to that. Anyway, just before I go back to that, I just want to read what Abdel Nasser said, Grand Mullah, and actually there was a lawyer who quoted him. Okay, now let's get to what I just said. Here is what I showed, and it's funny how Abdel Nasser was really kind of accurate in his prediction. Tuangalie, before I get you back to that low Milimani quotes, so we can hear the proceedings. Okay, here is Abdel Nasser. This is what Abdel Nasser said. Listen to me carefully. Can you read it? Okay. So he said, one, so today, can you guys see it on the screen? Look at it on the screen. Look at that. Look at that. Look at that. Look. Is it there? Is it there? All right. There it is. So this is what Abdel Nasser said. So today, the High Court will rule on whether the DCJ Mwelu has powers to impanel judges to hear constitutional petitions. And he gives his prediction and says, Gachagua will not win this. Came to pass. So he knew. I know you're sitting at home saying, oh, he's a lawyer, so he probably know how this will go. Not really. But anyway, number one, Abdel Nasser is right about that. Again, so today the High Court will rule on whether the DCJ Mwelu, Deputy Chief Justice Mwelu, has powers to impanel judges to hear constitutional petitions, and they say Gachagua will not win this. Okay. Two, Abdel Nasser say the court will hear the disqualification application. Gachagua will not win. The disqualification, isn't it the same thing? Kind of, basically the disqualification as far as this judge is presiding over this case. I think that's what he means. Gachagua will not win. In effect, he didn't win on that too. Three, stay application pending appeal will be argued. Gachagua will not win. I haven't had anything about the stay application, but I think as we listen in, probably there will be an application of the stay order, okay? And Abdel Nasser says stay order basically to, hold on to that judgment. They want to appeal the case. And I think actually this is what's going to happen, but it's already, they're going to argue that tomorrow, because as you had that one lawyer representing Gachagua said, tomorrow, I think he'll be there in 11. And Paul Mwite also said that he'll be there at 11 a.m. tomorrow at the courts. The courts shall be open at 9. And I guess they will, sit down and conjure up a plan of how to persuade the courts to issue a stay order so that they can appeal. Like you had them say they would like to have a 5-man panel bench, okay? Judge bench, okay? A bench, okay? All right, let's go to number 4. So you see, everything since 1, 2, 3 is happening, just like Abdel Nasser predicted. Number 4, application on whether state offices in the Senate and National Assembly, including departmental heads, can represent parties in court, will be argued. Gachagua will win this. This hasn't happened yet. The fact that Ojienda represents the Senate and there's some other guy who's represented in the National Assembly, I forgot his name, is one of the lawyers. It's baffling to me. I mean, this is another arm of government being represented by specific lawyers. It's just baffling to me. Personally, I don't know, but we'll see. I guess that matter will be, I don't know if that's what they're arguing now or they're about to talk about now. We'll see how the judge will adjudicate on that. Then number 5, then main application will be had. Again, that is yet to be done. I think that's what they are about to do. Number 6, ruling next week. So according to Abdel Nasser, it's probably ruling next week, ruling about the whole thing, impeachment and all that stuff, or end of next month, inshallah, okay? Or end of next month. So we might wait till end of November, to hear about that stuff. Okay. So that's what. So far, out of those 6 things, 3 already just went exactly how Abdel Nasser Grand Mullah has predicted. Now, another prediction that he gave really quickly before I get you back to the main thing that I know you're listening to the Milimani Court's proceedings. He said, again, I'm rereading, the conservatory order will be discharged by the 3-judge bench latest by next week, if not by Friday. So this bench, these judges shall lift that conservatory order that's in right now. Once I think it has been established that they will preside over this case, that's when they will deal with this conservatory order. And I already saw Gideon Muigai and the gang already, wanting the judges to get on this matter immediately. They want to start their arguments, okay? All right. 2, Professor Kithure Kindiki will be sworn in as deputy president. That's his prediction. 3, both the High Court and the Court of Appeal will quash the impeachment of the Honorable Rigathi Gachagua on the ground that he was denied the right to be heard during the Senate trial as he was sick. Both courts will order his immediate reinstatement. So he's saying that this 3-panel judge, if they go on, or the Court of Appeals, if they go to the Court of Appeal, they'll quash the impeachment and they'll say that he needs to be reinstated since he was not afforded time to be heard because he was sick and, there was no time. They never afforded him time to be cross-examined. Right to habeas corpus, okay, produce the body and represent yourself. So, yeah, that's a possibility. Number 4, right there. The Supreme Court deploying the juris pesa. If you know about juris pesa is basically the jurors or the judges being paid for a particular ruling. So the Supreme Court deploying juris pesa will hold that fine. Gachagua was denied the right hearing, but he can't be reinstated as Professor Kindiki is on office. So basically, when this matter will finally reach Supreme Court, the Supreme Court will say, yes, we agree that Gachagua was denied the right to be heard, but we already have a deputy president, so that has been with events of what do they use? Whatever. Petition. We're here to see, and this is again. Ahmed is saying after the Supreme Court has been paid, of course, Ruto will write the check, and the ruling will be, alinyimwa haki zake, not to be cross-examined and represent himself physically by the Senate, but we already have a new deputy president. That one has been overtaken by events. So, Kindiki endelea. Then number 5, somewhere in between, don't rule out of court settlement, whereby Gachagua's impeachment is set aside and he's agreed to go back to Mathira to fight another day. So in between, while the Supreme Court will be good, there'll be a lot of fluff and waffling and drama in all this. There'll be a lot of drama in all this. For the next 2-3 months, we are going to be fed this Gachagua nonsense. It's going to take our time. And we'll be here for it. Like famous quote from Pep Guardiola, the Manchester City coach, says, we'll be there. We'll be there. We'll be there. We'll be there. We'll be there for it. We'll be there for the bullshit, as some would say. So, like I said, 3 of the Abdel Nasser Grand Mullah's predictions have been realized. Are we ready to go back to the courts? Let's see what's happening in the courts, and we shall continue with the coverage of Gachagua stuff. Do not forget, ladies and gentlemen, brothers and sisters, if you're just joining in and if you're watching also on X, please come to YouTube. Take your time, go to YouTube, find me. My name is Kindiki Revolutionary. As you can see on the screen, on the left side of the screen, left or right, whatever the case is. Just side of the screen if you're watching. And go ahead and subscribe, share, like, comment, and do whatever you need to do, okay? So we can, what did I say? Do whatever you need. I'm saying if you're just joining, if you're just joining this channel, you're watching me, giving my analysis and my take, and we're discussing all this wonderful stuff. Please take your time, your sweet time, a minute or less, second. Press on that subscribe button, like the video, share, subscribe, do all the good stuff, okay? As we continue to break down and analyze and see what's going on with this Gachagua impeachment and other stuff that's happened. By the way, by the way, apparently Kindiki was supposed to show up in the Senate because they wanted to ascertain the truth as to whether he is a CS or is a deputy president. What's the deal with him? But Kindiki skipped town. He was like, you know what? Fuck this. I'm not showing up. So anyway, Kenya kuna vituko. I mean, we are being, this is, I don't know who's writing these scripts, but whatever. Anyway, let's get back to the Milimani quotes and follow up. Let's see what's going on with Gachagua and the gang. And is it principal is telling us Kenya only God can save. Absolutely. All right.
Yesterday, I pointed out to the
You have to turn your volume up just to listen to this.
proceeding with the discussions on the Conservatory Orders would have prejudiced us because then we would have lost out without participating.
Judge.
Our prayer would be
No. We need to make progress.
All right, this is, I'm going to stop here, ladies and gentlemen.
Application. We are taking so long.
Just tell us, Mr.
All right, I will stop here basically because this is taking too long. It's kind of boring. I will be back later for a full analysis of what happened and other news regarding Kenya. Subscribe, share, like, comments, and I will see you guys later. I'm out. Peace and blessings. Peace.